Ladies and gentlemen, good evening, good afternoon. Welcome to our presentation today. After the very exciting build-up music, you're clearly all anticipating something very exciting. We'll do our best to keep you interested at what is, I'm conscious, a very late stage of the week in Astana. Thank you all for participating in this conference. We on the panel are very honored and delighted to be part of this very exciting program by the AIFC, albeit in virtual form, and some of us had to go and find ties which had not been used much for many months. The format of the session is that I'm going to give a few introductory comments to set the scene of our presentation, and then I'm going to hand over to Aruzhan and Maksim from Grata, who will go through their own presentation. As you will be aware from other events, this is being translated. Apologies, but I'm afraid I only speak adequate English, so I am relying on the translators for other presentations and questions. Following the presentation, there will be an opportunity for questions. If you put them in the chat box, we'll try and pick them up and address them as part of the presentation. And if there's an absence of questions, I have lined up some challenging questions for our colleagues, and hopefully they will be of interest. There was an FDI presentation, which many of you may have participated in or listened to this morning. And this is really an evolution of that, a development of that, looking at the practical example of the way in which AIFC Law and structures is encouraging, among other activities, foreign direct investment into Kazakhstan. As I'm sure you'll all be aware, the AIFC financial and commercial ecosystem has a number of key ingredients. These include the financial participants, those who are carrying on regulated financial activity, from the AIFC and are subject to AFSA regulation, non-financial participants, such as lawyers, accountants, and so forth, other service providers, including hotels and all the other things which keep us all going, and fundamentally the underlying businesses, those businesses which are looking to use the AIFC to raise funds and or to use the mechanics and systems of the AIFC to implement M&A transactions. Over and above that, there's the regulatory and administrative structures which have been set up to encourage and support and regulate activity, and many specialists who are available to help in those who wish to use the AIFC functions. The dispute resolution regime with the court and the International Arbitration Center are the subject of a number of separate presentations and are clearly a fundamental element of the AIFC infrastructure and ecosystem, and are available for those who are participants or not, and contracts which are governed by AIFC law or not. The physical site, some of you may be there at the moment, a hugely impressive and exciting complex, which I haven't been able to get that to for some months, but clearly the basis of this, and then the tax regime, which is beyond the scope of this presentation today, but is clearly fundamental. As you will all be aware, the AIFC mission is to contribute to the sustainable economic development of Kazakhstan and the region by fostering innovative financial products and services, by establishing an environment that delivers fair and transparent financial and capital markets in which individuals and institutions act with integrity. These are also fundamental elements of this. As such, it is a key objective of the AIFC to encourage international and domestic investment into the Kazakh economy, both large companies and SMEs, which are obviously such an important part of the Kazakh economic environment. And this is done through the ability to create legal structures, including public and private companies, limited partnerships, LLPs, and other vehicles, which are based on common law structures and which are likely to be familiar to many international investors, which may assist in their ability to support and enter into contractual arrangements with such entities. Thus, businesses may establish companies and other entities in the AIFC, not only for the conduct of financial services activities in or from the AIFC, or indeed in mainland Kazakhstan, but also as operational companies for carrying on normal commercial trading activities, but also as holding companies and financing companies. Holding companies may be established on top of existing Kazakh businesses, and this is what the presentation will address in a few minutes, in order to facilitate and encourage the introduction of international investors, including through listing their securities on the AIX. And I'm conscious of a number of companies which are looking at this mechanism. And obviously there are already some very successful listings which have been implemented internationally and on the AIX. Raising money on a non-publicly traded basis, it's equity subscription of one sort or another, or acquisition into AIFC holding companies, and through joint ventures and other cooperative structures with international and with domestic investors. In the case of group finance companies, this could potentially include listing of debt securities on the AIX, and then the proceeds of those issues being applied down into the holding structure to finance Kazakh businesses in their trading operations. A key second limb of the AIFC legal structure is, of course, to enable companies to choose AIFC Law, which, as we all know, is based on English common law, but adapted for the best practice across a number of international centers to govern their commercial relationships, whether or not there is any involvement by either of the contracting parties or any of the contracting parties otherwise in the AIFC infrastructure, but also the ability to select, as we've discussed, dispute resolution forum in AIFC through the court or the AIX, International Arbitration Center. All this is against a global increase in M&A activity. The COVID and winners and losers, clearly some companies have come very well out of COVID and have been able to build up significant cash resources and have had successful businesses. Others have suffered more from all the issues associated with COVID and its challenges throughout the world. And this has created of itself quite a lot of M&A activity of companies merging, combining, or acquiring other companies, and generally raising money to take advantage of opportunities or to meet cash shortfalls. Clearly, government activity throughout the world is doing its utmost to regenerate economies, and this is putting a lot of money into the system and again encouraging M&A activity. Very low interest rates are encouraging investors who are sitting on huge piles of cash to find attractive returns from companies and businesses which are securely structured and which obviously have the potential to produce an economic return. And using AIFC structures as part of this is obviously a great opportunity. There are development of new financing systems, which AIFC is clearly at the forefront, development further of Islamic financing, fintech, cryptocurrencies, and all these things which are playing an increasing role in global financing. And generally a greater level of cross-border activity with the AIFC being really well placed, both for FDI into Kazakhstan, but also as part of their mission, the implementation of M&A transactions across the region. A key element of this, of course, is the expertise of participants. And this is absolutely not a question of what law is better than another law, but providing a supplement to mainland Kazakh law, which can promote the Kazakhstan and provide an opportunity of itself for the financial and economic activity within the AIFC. And the involvement of domestic and international practitioners is absolutely fundamental to this. This is absolutely not a situation of external lawyers coming and saying this how it should be done, but the involvement and active participation of a huge number of highly skilled Kazakh lawyers is fundamental both to the current activity and to the future success of the AIFC. And as part of this, an example of this is the presentation we're now going to hear from Aruzhan and Maksim, which will look at the way in which the scheme of arrangement under AIFC law is being used to create the amalgamation of an AIFC entity with domestic trading operations. So with that, I'd like to hand over to our two Grata speakers for their presentation. Thank you.
Thank you very much, Simon, for a thorough introduction. Let me introduce myself. My name is Maksim Burak. I'm the Director of Corporate Practice in Nur-Sultan, in Astana, in Kazakhstan, Grata company, and my colleague is Aruzhan Aimak, a senior lawyer of the corporate practice, also here in Nur-Sultan. Going into the scheme of arrangement topic, let's look at the following slide. First of all, I would like to mention the fact that the scheme of arrangement by itself is quite a comprehensive mechanism that implies sanctioning some kinds of agreements between the parties, and the parties could be the company, the participants of AIFC itself and its shareholders, or a class of participants if those were identified, or the creditors or a group of creditors. At the same time, in order to trigger this process of scheme of arrangement, one would need an agreement of 75% of the shareholders or creditors. This was just in a way of a general introduction. At the same time, the AIFC law allows the direct opportunity of the AIFC court to sanction some agreements between the parties or increase its force. It can either be a reconstruction or joining of the AIFC company, and according to these acts, this could be not only the other participants of AIFC, but also the company, another company in Kazakhstan, which brings forward interesting opportunities. To launch this process, it is important to have the necessary court order, which would talk about the dispute, not in a sense of confrontation, but rather a formalized arrangement between the parties. And in this request, one needs to demonstrate that the parties have agreed that there will be an acquisition or merger of the company. And this aspect overall is interesting because on the one hand, it allows to use the AIFC law and its flexibility. And on the other hand, it allows it to use the mechanism for M&A transactions in the Kazakhstani legislation in its relative well-regulated format, and this can amalgamate those two legal systems, which aren't easy to combine. And one of the important aspects we see here is that according to the laws of the Republic of Kazakhstan, the decisions of AIFC will be enforced throughout the territory of Kazakhstan, like with other decisions of regular courts. So this allows us to bring these two mechanisms together and basically transfer the Kazakhstani company into AIFC umbrella. So therefore, there are some preliminary steps that need to be taken to launch this process, and those steps follow, I guess, the description of such M&A itself. So first, it's the first step is setting up a company in AIFC, also conducting a preliminary check and receive the required consents. This might be some consents which are required based on the current activities of the Kazakhstani company, or this could be consents of banks or creditors. It is important to check the correspondence of the types of activities of the company which is merged to make sure that there will be no problems in the future, that this company won't require a special license in AIFC, because for those instances you would need to obtain those licenses, and also you need to check for possible consequences of these amalgamation on a case-by-case basis to make sure that all of the aspects are taken into account, because the scheme itself is not a classical scheme, and to some extent it uses the mechanics that might not have been foreseen or intended by the creators of those legal acts. However, in our practice, and I will show you the case later on, from our practice, we can see that those mechanisms do work. Aruzhan, thank you, Maksim. Good afternoon, dear colleagues. Allow me to continue our presentation, and I will talk to you about the procedure of how an OLP can be joined with the private company registered in AIFC. I seem to have some difficulties in advancing the slides. So first of all, the company, an OLP and a private company, both companies need to make a corporate decision on this merger, and these decisions will take into account these agreements, the notifications of the creditors, and the decision itself on the merger, and other aspects which the participants might consider important. For instance, authority of some individuals of conducting different actions during reorganization procedure, or like our clients had, of hiring a legal company that will be involved in the procedure. In this step, it is also important to note one thing. Corporate decisions, when preparing a corporate decision, you need to identify which body in the company will be authorized to make certain decisions. So if we're talking about an LLP, according to the law on limited liability partnerships, this has to be a decision of the highest governing body of the LLP, a sole founder, or the partners, because according to the law on LLPs, Article 43, reorganization is the matter of exclusive competence of the highest body. Also, for a private company, we also recommend to have the decision of the highest governing body of the company, as Maksim has mentioned, to launch the procedure. To launch this M&A procedure, you need to have an agreement of at least 70% of the shareholders for this transaction, and therefore we also recommend this to be made in the form of a shareholders' decision. Plus, it's important to check the charters or articles of association of a private company, because in addition to the general meeting, there can be other bodies in a private company, like a board of directors. So it is important to make sure that for reorganization, a company does not need a preliminary approval of this transaction by the board of directors. In our practice, we have seen the situations when the charters of the company, although the company had several corporate bodies, the charters did not clearly distinguish between the competences, the powers of each body, and it was unclear whether it was enough to get a decision of shareholders or an additional decision of the board of directors or other governing bodies were required. So in this regard, in order to eliminate any future disputes, we recommended to our clients to make a decision on reorganization on all levels, just to make sure, using the general meeting and the board of directors, although this might not be the best corporate practice. So that is why before the start of reorganization procedure, we recommend to review the charters or articles of association and to amend them when necessary to eliminate these collisions. And second step is notifications. It is important to notify the tax bodies. That is the requirement of the tax code. Within 3 business days of the decision making, you need to notify them. We recommend in practice to send them a notification and get it stamped to confirm that the tax body has received this notification, and this will then serve as a proof in the future if you will require it. Plus, you need to notify the creditors. Again, this has to be done in writing, preferably you need to obtain a signature that the creditors have received this notification, and you also need to publish this in the press. It is important to do both because this is one of the provisions in the law on LLPs. The AIFC law does not specify these notifications by private companies, but we recommend to do this as well to avoid any possible disputes or claims by the creditor against this private company. But for LLP, this is a mandatory step according to the law on limited liability partnerships. The third thing is actually signing the M&A agreement, and this agreement is also stipulated in the law. It has to contain at least the information on the participants in this M&A, the registered official address, banking details of those companies, data of the balance sheet, amounts of assets and current liabilities of both companies, and also the provisions and action plan for this M&A of when the parties need to prepare certain things, certain documents, what are the deadlines for approval of the documents, who will be involved in submitting the requested documents, when the submissions need to be done to the government bodies, who bears the costs, and so on. And it's also recommended to identify some provisions related to the company you will end up with, meaning what the company will look like after the M&A transaction is completed. This is usually a description of what the equity of the company will look like, whether it will increase or not. We seem to have difficulties with the sound of the speaker. So we need to launch this system. The speaker's internet connection is not very well. So in this regard, when we apply to court, if that is done by the private company, it is recommended to provide as many details of the case as possible, specify why the creditors, the shareholders, and those companies, why this LLP and a private company have selected the scheme of arrangement mechanism, what are the benefits of this mechanism for their businesses, for their activity, and which are the benefits they can obtain through this reorganization. And also they needed to make references to codes and regulations to demonstrate that the court should issue this order sanctioning this M&A, and this is done under Article 126. Then it is important to attach confirmatory documents, all the facts and description of the situation that we specify in this request. This needs to be confirmed by the documents. Furthermore, it is important to provide confirmation that the companies have notified the creditors, attach copies from written notifications, and also publications in press. If possible, the companies could also attach the document specifying all the rights and obligations that will be transferred from the LLP to the private companies. Next step is the court order, and this step does not depend on the parties. This is done after the court proceedings, or like we saw in our case, we have submitted this request and the court issued a written decision. The specific time frame for issuing such order is not identified, and it all will depend on the court, and the companies need to be prepared that the courts can ask for additional information. They could ask for some additional documents to be submitted. In our case, this took about 2-3 weeks, so that wasn't a long time, and no additional documents were requested by the court, and it all went smoothly. And next, it's important to get the creditors' claims. Since the moment you notify the creditors, you have to wait for 2 months since the time of notification for the creditors to submit claims to these merging companies. And according to the law on LLP, they could also ask for fulfilling the liabilities ahead of time from the LLP. And the companies, when they make a decision on starting this procedure, they have to be prepared that they will have to fulfill some of their liabilities ahead of time. So you have to wait for 2 months since notification without proceeding with the reorganization procedure until this time is up.
Then we are preparing the taking over certificate as soon as we receive the requirements from the creditors. So we describe all the rights and obligations that are transferred to the private company. The requirement to the preparation of the taking over certificate, there are no specific requirements given that the LLP is merged to a private company registered at AIFC. That is, it is prepared the same way as if LLP is merged to another Kazakhstani company. Then we prepare the liquidation tax statement. During this 8th stage, we need to have the tax consultants, tax specialists who will prepare the relevant documents in line with the tax code requirements. I would like to reiterate that there are no special requirements for these documents, given that the LLP is merged to the company in other jurisdiction, which is AIFC. These requirements do not exist. For step 8, the important thing to say is that the preparation of tax statements is not the same as the tax audit, which is carried out when the company is liquidated. During liquidation of a company, the company should go through the tax audit, which in practice may last from half a year up to 1 year, and therefore the mechanism or the choice of a mechanism of a scheme of arrangement compared to the transfer of all the rights and obligations to the private company and liquidation of LLP has such a big advantage because you don't have to wait until the tax audit takes place. Next step, step 9, is to prepare the corporate decisions to approve the taking over act certificate. The next step is that we have to submit to the tax body the taking over certificate, which was approved by the shareholder, and submit the prepared liquidation tax report. Step 11 is the corporate decision by the private company to make changes to the charter and making all other registration data in the private company. For example, if resultantly the private company increases the charter capital, the equity, then certain decisions should be taken to make changes to the charter, because the charter reflects the data about the equity, and notify correspondingly AIFC about those changes in this private company during 14 days. Why can we not do that step before? It's because from the date of decision taking, we need to notify AIFC about that. We couldn't do it beforehand because we haven't yet finished the reorganization process. The next is that we need to fill in the forms and supply the documents to AIFC. The next steps would be to stop operations of LLP, in particular to be merged to the private company. Normally, they would prepare all the documents and put them all together. In particular, they are the foundation document of the LLP and also the submission of the documents to the National Corporation Government for Citizens. I should note that this application should not be submitted earlier than 2 months from the date of notification to the creditors, which I mentioned before. And the last stage, the last step is to receiving the order of termination of operations of LLP because of the merger. We have brought light to the key steps based on our experience during the merger, and you can notice that during the merger procedure, we relied upon both the requirements of the law of Kazakhstan and requirements of AIFC. Maksim, the floor is yours. Thanks all from my side. Aruzhan, thank you very much. Distinguished participants, as you can see, Aruzhan, can you show the next slide, please? Speaking about the cases when this is needed and why this is needed, we should note an important thing here, which is a significant difference from Kazakhstan jurisdiction, general jurisdiction, and AIFC jurisdiction, which is both the applicable law and the tax regime. These are the two main differences, including the import of labor and so on. Quite often in our practice, the clients will receive questions as to how, being registered in Kazakhstan, we could gain certain benefits and advantages from jurisdiction of AIFC, how we can make the business happen to be there at AIFC. And quite often the companies face the issue that if they just establish the company under AIFC and transfer all the assets, there would be a number of complexities. Number one is that they lose the legal personalities of the initial legal entity. So it would mean that this is going to be an absolutely different company. Therefore, you will have to re-sign certain contracts and terminate some operations of the companies in Kazakhstan and start some of the operations almost from the scratch under AIFC. And also the need for facing the procedures of liquidation of the company in Kazakhstan, which could be a lengthy procedure. And as Aruzhan mentioned, that the tax audit can take up to 1 year due to various circumstances caused by the process of the audit and so on. All this makes, in our view, this procedure of transition pretty interesting option for the companies to transfer their business to AIFC. In particular, it's a kind of the alternative to re-domiciliation. As you can be aware that legislation of AIFC offers the option of re-domicile from AIFC jurisdiction to any other jurisdiction and vice versa. However, for Kazakhstan legislation, in Kazakhstan legislation is not this re-domicile is not possible. Therefore, the law on the AIFC law states that it would be more difficult to re-domicile the legal entity from AIFC to Kazakhstan jurisdiction. However, it is possible, but from Kazakhstan to EAFC, it is absolutely possible. And this scheme and this approach could be useful in principle when there is a need to relocate the business from jurisdiction of Kazakhstan to AIFC. That will in turn provide the option to use the advantages and benefits of AIFC including tax benefits when they carry out certain target operations, and so on. In addition, there are a number of other differences that Aruzhan has already mentioned. They include when using such scheme, if we compare it with the standard transfer of business to AIFC, is that you don't have to go through the tax audit, which can take a lot of time. In case if you liquidate a Kazakh company, there will be no need to lay out the staff and employ them again. For some major companies, these HR issues could become a significant issue. This also provides the option of taking advantage of certain mechanisms of Kazakhstani legislation that provide for transfer of some things that could not be transferable. I'm talking about certain licenses which otherwise will have to be withdrawn. They will become invalid and get reissued again. And these could also provide some other benefits. And in general, it allows preserving certain legal personal identity of the legal entity, and based on a number of operations, for example, subsoil use contracts, the liquidation will cause termination of the rights and obligations under the subsoil use contract. In this case, it could be avoided. As by way of summary, I can say that, as I said before, the mechanism is pretty effective and pretty powerful. That opens for Kazakhstani business after a number of steps, which I don't think are going to be cumbersome, and they could be called manipulations. That's all from my side, from our side. Simon, if you have any questions, please.
Thank you, Maksim, very much. I've got a couple of questions, and there's one particular question from a participant, which is, can you please tell us if you managed to register the termination of activities in the authorized bodies of Kazakhstan and exclude Zeren from the national BIN, business identification number register, after amalgamating with Unicorn, or the termination of activities of Transtechnol after joining Bizone. And the author went on to say the above question arose due to the fact that these LLPs are still in the NIB. Now, my understanding is that the process has not yet been concluded on the basis of the timetable you described. But so I think that may be why those entities are still on the register at the moment. But I've got sort of two questions in relation to that. One is the specific question is, upon completion of the amalgamation, will that result in the them coming off, the companies coming off the register? And second, related question, I guess, is if you are a contractor with one of the LLPs historically, and the process has gone through, once the process has been completed, what is the party with which you are then contracting?
Yeah, many thanks, Simon, for these questions. So first of all, answering to the first question, yes, upon completion, full completion of the procedure, the Kazakhstani LLP will cease to be in Kazakhstani BIN database. So it will see the Kazakhstani legal entity, the LLP will cease to exist. It will be wind up. As to the second question, upon completion of this procedure, if you're a contractor of this Kazakhstani LLP to be amalgamated to AIFC company, you will be a party to the contract with AIFC company, not regular Kazakhstani company. This is intended to keep all your rights and obligations and all the rights and obligations of your counterparty, which is now AIFC counterparty, but still it will be like a legal entity located in another jurisdiction, in the AIFC jurisdiction.
Thank you. Just following up from that, if there had been some dispute going on prior to the implementation of the transaction, is the position simply carried forward into the new company? So any subsequent court proceedings would be on the same fact basis?
The consequences will be the same as they would be if a Kazakhstani company, which is subject to this court proceeding would be amalgamated by another Kazakhstani company. So very same story, and the same Kazakhstani civil procedure code provisions are intended to apply. So in such a case, if nothing prevents the Kazakhstani LLP from this procedure in terms of its current litigations, the AIFC company will become respective party of a litigation in hand.
Okay. Thank you. And perhaps a related question. In the presentation, Aruzhan indicated that you had to get consent from creditors. A large company could obviously have a very large number of different creditors. And I noticed that you have to make the public notification in compliance with the AFC procedures. But which individual creditors would you need to contact? Is there an element of size or proportion of your liabilities?
Generally, Kazakhstani law requires to notify the creditors. I guess Aruzhan may have some more details and more insight on this. Aruzhan, please go on.
Да, спасибо большое за вопрос.
Thanks a lot for the question. As I said in my presentation, you have to notify the creditors, but you don't necessarily need to get their consent. It is important to notify them and wait for 2 months. If within this period the creditors don't use the right to issue a claim under the current obligations of the companies and could require the execution of those obligations or liabilities ahead of time, but there is no need to get their consent for that, for the merger. Therefore, if the company under merger has a lot of creditors, this issue can be addressed like this.
Thank you. And just as a supplemental to that, is the notification to creditors, can that be done exclusively by formal publication?
Нет. Необходимо подавать и письменное уведомление, и делать объявление в газете.
No, you should do it both as a publication and also provide it in writing. Both conditions have to be complied with in line with the law on LLPs.
I see. And if an individual creditor raised an objection, even if they were only owed a very small amount of money by the company, would they be able to block it, or is there an ability to go to the court and challenge the claim?
The law doesn't differentiate the opportunities of creditors to issue claims, irrespective of their legal form. It could be even an individual or a company, and there is no differentiation by amount of the claim. Let me add here, the question here is rather whether any of the creditor with insignificant amount of claim block the entire procedure and if he expresses his objections. In this case, it's not like this. The creditor cannot block it, but he can ask or require the repayment of liability ahead of time. And if this liability is repaid, and therefore the disconsent of this creditor will have no sense, because obviously he stops being the creditor of the company under reorganization.
Thank you very much. I don't think at the moment we've got any other questions from external participants. So I'm going to ask one more question, if I may. In terms of this structuring, You pointed out some of the advantages of that, which was very encouraging. Is it the case that this is largely dependent upon or this choice is largely dependent upon the way in which regulatory issues are dealt with in mainland Kazakhstan? Or is this a mechanism which you think is useful in the wider context, even if there is no question of any other process involving regulatory consents or the termination of any licenses?
Well, basically, I suppose it's always more or less both. So, first of all, yeah, you obviously face this regulatory side. However, even without this side, you may still wish to keep the legal entity intact. You may wish still to keep it existing at any moment of time. And yeah, I mean, if you're speaking about the choose between this procedure, the scheme of arrangement procedure, and other options of moving the business to AIFC jurisdiction.
Thank you. Having said that was my last question, I do have another one. In terms of the selection of the AIFC holding company, could you comment a bit on that in terms of taxation? We have just a couple of minutes left. In terms of if people are looking at different jurisdictions in which a Kazakh business may establish a new holding company, do you want to say a few things about the choice of the AIFC as a venue for that, please?
So, first of all, if we're talking about moving the business to some other jurisdiction, as of today, AIFC seems to be the only straight option because Kazakhstani law does not provide any mechanisms to move a regular Kazakhstani company to outside of the country. And that is why it is the only option for a Kazakhstani business where they can move and enjoy respective benefits of AIFC jurisdictions. And mostly in our practice, those benefits which businesses regularly pay attention to are the flexibility of AIFC law, first of all, the corporate law, flexibility of AIFC contract law, and also, of course, some tax incentives which are also very interesting for depending on the business activity.
Okay, and we have one final question from a participant. I'm just quoting it. Is clause 17 of the interim procedure for entering information on the Astana International Financial Center bodies, their organizations and participants of the AIFC into the National Register of Identification Numbers and assigning identification numbers a barrier? And the questioner goes on, reorganization of a legal entity shall be carried out in cases stipulated by the acts of the center. Participants of the organization could only be the center bodies, their organizations, and center participants. Quite a complicated question, which I'm not sure I fully understand all the implications of, but just dealing with the last point, then I'll hand back to you for the first part of that as a conclusion of our session. My understanding is that it is not necessary for both participants to be both participants in the scheme to be AIFC entities, as indeed was not the case here, provided one of them is, and for a scheme of arrangement, I think that would have to be the acquiring entity. The others could be incorporated within mainland Kazakhstan or indeed anywhere else. Is that correct?
That's correct. The other party can be incorporated anywhere else, but it seems to be maybe a bit more complicated for this second party to be incorporated somewhere outside of Kazakhstan, because this obviously requires deep analysis of respective legislation. But for Kazakhstan, yeah, that completely works. And as of now, we are still in the process of the amalgamation in hand. But as of now, we don't face any kind of objection from any regulator in this respect.
Okay, thank you very much indeed. I'd like to thank both regard to participants for their very interesting presentation and their astute answers to the questions. I would like to thank the AFC team for organizing all this, and I'd like to wish you all a very excellent weekend, wherever you're located. We're now finishing the presentation. Thank you very much indeed. Goodbye.
Спасибо большое. До свидания.
Bye. Thank you.
Thank you very much. Goodbye.